of his team, I believe, as well. Mr. Attorney General.
Mr. Chairman and ranking members, can you hear me?
Yes, we can hear you. Good to see you.
Yeah. Hi, good to see you. I apologize for coming to you from New Haven, but it's a crazy day, and the mayor let me his conference room. Thank you so much for giving me the opportunity to address the committee today and to speak about what we've come to know as the Dodd-Frank bill. Let me first say that I miss very much my very good friend Bobby Miller. And for those of you who didn't know him, he's a wonderful man and a wonderful father and husband and great friend back home in Stamford. And he fought his disease for a long time, and he fought it well. And frankly, at various times had it beat. And so, you know, we just miss him. And I just want to offer my condolences to Senator Miller and her daughters and their family, and just wish them peace and comfort in this difficult time. Moving on to the business at hand, I want to thank the Department of Banking and the Commissioner and Matt and Joe Chambers, the Chief of Staff, for working with us collaboratively on this bill and Senate Bill 121. Just by way of review, we've been here before on this bill, and for members of the committee knows better than anybody else that in 2010, our own Senator Dodd worked with then Representative Barney Frank to pass Dodd-Frank in the wake of the financial crisis in 2008. And as part of that, empowered both the Consumer Financial Protection Bureau and state attorneys general to enforce the terms of Dodd-Frank, federal banking laws, state banking laws, and state consumer protection laws to protect consumers, particularly in banking and financial transactions. As a follow-up to that, in 2011, this legislature, the state of Connecticut, in what is now Section 3-129D, expressly empowers and authorizes the Attorney General to bring a civil action under Dodd-Frank pursuant to its concurrent authority with the CFPB under the Consumer Financial Protection Act, the CFPA. One omission that we think is important to clarify is that while we can bring an action, so I could file a lawsuit tomorrow, it does not make clear that we have pre-lawsuit investigative authority to issue subpoenas, collect documents, seek testimony, do all the things the Attorney General does every single day in protecting Connecticut families and consumers and enforcing the law. And so while that authority, I believe, is implicit in the explicit statutory authorization in 3-129E, at this point, we think it makes good sense to clarify that in statute. Again, this has been the product of a lot of hard work by the commissioner and his team, and in particular, the Chief of Staff, Joe Chambers, in coming to an agreement in which the Attorney General's office and the department come together before we issue a subpoena. We give them notice, we can have a conversation about it, and we can work together collaboratively to move forward to protect consumers. Let me just say that this is really important to people here in Connecticut. After we saw what happened to Connecticut consumers with M&T Bank, and we talked about that on this committee last year. We've received more than 400 complaints and counting, and it would have been helpful with M&T to have clarified that we had that pre-suit investigative authority. It would be helpful in taking on, for example, for-profit colleges that maybe encourage students to take out tens of thousands of dollars in student loans, and then the school closes. That might have given us the opportunity to protect students here in Connecticut, for example, students like those at Stone Academy. There's another, what I consider to be a scam going around now. You may have heard in the last week, there was news coverage of MV Realty and a product that they're shopping around Connecticut where they offer people a few $100s or a few $1,000s to sign away their rights to market their property for 40 years. And so people are, I think, getting snookered into signing away their rights for a small amount of money, where this company, MV Realty, has a cloud over their title that's on the land records, where if they try to sell their property, MV Realty gets 3% of the proceeds. And there are more than 400 consumer contracts of that nature. So a lot of issues out there. A lot of people need our help and need this committee's help. And passing Senate Bill 121 would go a long way to giving us the authority and the muscle to protect consumers and banking customers. Thank you. Happy to answer any questions.
Thank you, Mr. Attorney General. You touched there on what was going to be my first question. I was interested in to sort of break it down for the committee. I was going to ask, since we last convened on this last year, in the midst of some activity in the banking world, I was going to ask if there have been any other instances in which you think these powers would be helpful, and then if you could maybe just describe what Dodd-Frank is intending to capture in terms of the types of these or activities. You touched on it a little bit there, but I was going to ask you to elaborate.
So great question. And frankly, the list is so long of potential actions that we could take, because what the CFPA covers are financial transactions and products in which consumers participate. And so if you think about all the myriad financial products that are offered to consumers today, right? All these, not just mortgages, not just loans, not just commercial retail banking, but I talked about this MV Realty scheme, debt relief, debt collection. There are so many areas in which there are financial products or transactions that involve consumers, and the CFPA is intended to cover all of that. What's really important about the CFPA is that the CFPB, the Bureau, administers a consumer restitution fund. They've got, frankly, lots and lots of money there to try to help people who have lost money in a financial product or transaction that has gone awry, in which the CFPB and state attorneys general have authority. And we can come together and use the authority, leverage the authority of the federal government and the CFPB to not just take action and sue somebody and hold them accountable, but get money to victims. And so that, I think, is a critical component that maybe we don't always have at the state level, but that the federal government has literally in its pocket to help consumers across Connecticut. So, there's a lot more to say about that subject, but we need to be able to leverage that authority so we can get out there and help customers of M&T, potentially help students like those we saw at Stone Academy and are trying to help now, like victims potentially of MV Realty. Frankly, to the extent that there are complicated consumer financial transactions or products around solar panels, right? And people are being taken advantage of in buying solar panels or in the marketing of solar panels. That's another good example. So many areas in which we can weigh in and protect people.
No, that is a good example, and I agree. Oftentimes, and we see it when we're looking at legislation here, we get hung up on who is the regulator of primary jurisdiction, and do we go there, and how to coordinate that, on behalf of our constituents and consumers in the state. You illustrate why it would be helpful to have another venue or another place or someone else who can help defend the consumers in Connecticut. when it comes to these things. So appreciate your testimony and for bringing this to us again for, I think, the second year, maybe the third.
Thank you, Thank you, Mr. Chairman. Yeah, it's the third year, I think, and I want to note, that sometimes there's a question about who the regulator is and the regulator of first resort, or who has jurisdiction. In this instance, the way I see it is the regulator is the state of Connecticut, acting through the Department of Banking, the commissioner, and the Attorney General, and the Office of the Attorney General. But we're all on the same team. We are the regulator. The state is the regulator, and so to the extent that we've been able to work together and find a path forward, that's because that's what we're supposed to do. And again, I want to thank the commissioner as my fellow teammate on these issues, because together we're the state of Connecticut as the primary regulator, as to people here in Connecticut.
Yep, well said. Representative Delnicki.
Thank you, Mr. Chair, and good to see you, Mr. Attorney General.
Good to see you. Wish I was with you in person.
I appreciate that. You touched on MD Realty scam that is going on, and what precludes you from doing investigative work that you would need the Dodd-Frank provision in a situation like this?
So I don't think anything precludes me, and we are focused on MV Realty. I don't want to talk too much about what we're actually doing, but we're focused on MV Realty, obviously, very focused, and my team here, Pat Ring and Phil Miller and others, are focused on it. That being said, 3-129 empowers us to bring in action. We could sue tomorrow. What it doesn't do is make clear and explicit that we have the pre-suit investigative authority under Dodd-Frank to bring an investigation. And it would be helpful if the statutes clarified that. Now, that being said, MV Realty, to my knowledge, is not a state chartered banking institution. It is a private company offering a product. So maybe that's not entirely apposite to what we're talking about. I'm not sure that it does invoke the department's authority, but to the extent that it does, this clarifies that there's a process for us to come together and to formulate a plan to move forward, to investigate and take action to protect consumers.
So what you've just described here, that if we were to actually implement Dodd-Frank here, that would clarify that? Would it amplify that? Or would it make much of a difference?
I think it would clarify and amplify, frankly, and put bad actors on notice that if they try to rip off consumers in Connecticut, we're going to come after them.
Okay. Well, thank you, Mr. Attorney General. Thank you, Mr.
Thank you, Mr. Ranking Member.
Senator Berthel.
Good morning, Mr. Attorney General. Good to see you. Sorry you
Good to
couldn't
see you
with us here in Hartford this morning. So I know that there's been some written testimony submitted by two of the large shareholders that represent banks and credit unions regarding this bill, and it looks like the overall theme was that they were hoping that your office and the department would come together and fix some of the issues. So we're going to hear from those shareholders a little bit later this morning as well. But I just wanted to offer my appreciation for finally getting us to a point where we think we can move something forward. It has been 3 years, I believe, that we've been talking about this, which I don't know, seems to be the amount of time it takes for us to get a lot of things done, which is okay. But I appreciate your efforts here, sir. Thank you.
Thank you.
Thank you. Anyone else? Anyone else? No. Seeing none. Thank you, Mr. AG.
Thank you. Thank you, Mr. Chairman. Thank you to the committee.